Welcome back to Canadian Justice, where we're discussing a recent Supreme Court of Canada hearing that considered the question of when the Charter applies outside of Canada. So, Jesse, you represented the CCF in this case, and you've proposed a new test for when the Charter applies outside of Canada's borders. So, can you explain what the test is?
Yeah, so we propose that the court essentially recognize that the Charter applies to the executive generally without geographical constraint, but that the concerns that are expressed in its jurisprudence, that those are relevant in assessing Charter compliance. Sometimes within the rights, so Section 8, for example, says a reasonable search and seizure, or Section 1 of the Charter, which provides for limits in a free and democratic society. So the three-part test essentially is: one, are they acting pursuant to valid laws or procedures? Second, if that's the case, is the conduct of Canadian officials substantively different from the principles that emanate from the Charter on Canadian soil? And third, if there is a substantive difference, is that difference reasonable or justified in the circumstances? So it's when undertaking that third step of the test that we say that that's where the court can give the executive some room to maneuver. And we're proposing that it essentially adopt something called the shock the conscience standard. So that if the conduct of Canadian officials abroad is generally consistent with the norms of democratic societies around the world, that will be justified in that instance. But where it's conduct like torture or other circumstances that most democracies don't permit, that then the courts have a role and should intervene.
So, Jesse, to apply that test to the current facts in McGregor, which involved a search of his home where diplomatic immunity applied to his home had been partially, he argues, partially waived by the embassy, but the waiver didn't include a waiver to search electronic devices. This is McGregor's argument. So he says under the Charter, this was an unreasonable search. Would that shock the conscience of Canadians? How would the test you're proposing apply to the facts in McGregor?
Right. So in McGregor, as you say, the first issue is this question of diplomatic immunity. Did Canada waive diplomatic immunity, and was that waiver sufficient? So we say that question goes to whether or not the Canadian officials are acting pursuant to valid laws or procedures. So the court has to decide that question, and we don't take a position on that issue, but the parties did debate this. On the second question of whether or not it's inconsistent with the Charter, there are conflicting decisions in the courts below. So the trial judge appeared to take the view that it was inconsistent with the Supreme Court's precedent. The Court of Appeal appeared to disagree and say, actually, this method of proceeding, the warrant that was obtained was sufficiently clear. The search was conducted in a manner consistent with the Charter. So even if the Charter applied here, there really is nothing to see here. But we say to the court, if you agree with what seems to be the trial judge's position, and you get to the third step, you still have to determine whether it shocks the conscience. In my view, this case probably doesn't rise to that level because, as I say, we have a warrant, then we have a second warrant in Canada. So the conduct doesn't really seem to rise to that level. And the trial judge actually applied this framework in the alternative in his reasons. So he said, even if I had found that the Charter had applied, I would find no breach here. And so we recommended those reasons to the court. And so we'll see what they do with that.
Great explanation. I guess we'll wait a few months and see what the decision is. And if the court adopts this test that the Canadian Constitution Foundation has proposed. So, Joanna, if the court does adopt this test, how would that create better certainty about Canadian officials operating abroad? We've got about a minute.
I think there's just a lot of confusion about how Canada's human rights obligations sort of coexist with this rule about the Charter not applying. Here we have a clear principle in the Constitution. Executive action is subject to the Charter presumptively, and there's no man's land, basically.
Yeah, so, I mean, currently the law is just this patchwork, as Jesse explained. We've got to go to commercial, but when we come back, I want to talk about the idea of overruling the 2007 decision, which is a precedent of the Supreme Court of Canada. And there's been a big debate in the legal community recently, especially after a leaked decision from the US Supreme Court about what it means to overturn a precedent. It's an interesting debate. We're going to get into it in the next segment. We will be right back.